presentation by Justice Daniel Goundar, the High Court judge from Fiji. And the topic for his presentation is role of judiciary to ensure all tiers-based evidence. We're giving the floor, Justice Daniel Goundar. Thank you very much.
Yes, thank you. Madam Chair and members of the PILON working group, fellow speakers and commentators and attendees of this workshop. Good morning and Bula Vinaka to you all. It is well accepted that sexual and gender-based crimes are prevalent in almost every community. The victims are mostly women and children, and perpetrators in most cases are men. Ambivalence toward victims of sexual and gender-based crimes is undeniable and have roots in culture, religion, and history. Although it is reasonable to expect individual and society as a whole to demonstrate empathy for victims of sexual and gender-based crimes, reality is much different, even community reactions to sexual and gender-based violence vary from denial to neglect to look for an explanation for the perpetrator's criminal conduct and up to direct blaming of the victims, especially in cases of sexual violence against women and girls. Rape myths and stereotypes found their way into judicial reasoning by accusing women for tendencies to engage in fantasy, to be fickle or spiteful in sexual relationships, to be prone to sexual neurosis, or to be unwilling to admit consent out of shame, or that they often deserved to be raped on account of and demeaning. Sir Matthew Hale, Chief Justice in 17th century England, wrote that, and I quote, "It is true rape is most despicable crime, but it must be remembered that it is an accusation easily to be made and harder to be defended by the party accused, though never so innocent," close quote. Subsequent English cases endorsed Sir Hale's view to justify the rule of practice requiring corroboration or a warning that it is dangerous to act on the uncorroborated evidence of the complainant in sexual offences. We all know that the corroboration rule became part of the domestic law throughout the Commonwealth jurisdictions by requiring testimonies of women and girls in sexual cases to be verified with some other evidence independent from them in order for them to be believed. The rule placed victims of sexual offenses in special category of witnesses like accomplices in crime. Such requirements resulted in convictions which were solely supported on the complainant's evidence being regarded as unsafe and unsatisfactory and quashed on appeal. It gave the accused, in cases of sexual offenses, a protection which did not exist in other cases of serious criminality. And it almost certainly had the effect in many instances of deterring women and children from reporting sexual crimes or from cooperating in the prosecution of offenders. It is only in the last 2 or 3 decades when we start to see a change in paradigm shift and judicial rejection of the use of rape myths and stereotypes in judicial proceedings involving victims of sexual crimes. In many jurisdictions, including Fiji, the corroboration rule in cases of sexual offences against women and children had been either abolished by legislation or been struck down by the courts on the ground that the rule discriminated against women and children and contravened their right to equality before the law. All major human rights instruments, and in particular, the Convention on the Elimination of All Forms of Discrimination against Women, establish standards for the protection of women, including a prohibition on any form of discrimination against them. The Fijian Constitution has adopted these standards in its Bill of Rights provision in order to give full force and effect to the principle of equality before the law. Violence against women is as much a matter of equality as it is an offense against human dignity and a violation of human rights. The notion that rape is a sexual erotic act as opposed to a violent act has been renounced by international tribunals. In recontextualizing rape, the International Criminal Tribunal for Rwanda, the decision of Akiyusu, pointed out, and I quote, "The United Nations Conventions Against Torture and Other Cruel, Inhumane, and Degrading Treatment or Punishment does not catalog specific acts in its definition of torture, focusing rather on the conceptual framework of state-sanctioned violence. The tribunal finds this approach more useful in the context of international law. Like torture, rape is used for such purposes as intimidation, degradation, humiliation, discrimination, punishment, control, or destruction of a person. Like torture, rape is a violation of personal dignity, and rape, in fact, constitutes torture." Close quote. In Fiji, the definition of rape was widened with the repeal of the Penal Code and enactment of the Crimes Act. Rape and other sexual offences are now gender-neutral crimes. Women, girls, men, and boys can be victims of rape and sexual offences. A transgender person who has gone through gender reassignment surgery can be a victim of rape. The definition of rape includes different forms of penetrative intrusions of a person's body and is not limited to sexual intercourse. The definition of consent expressly rejects the notion that lack of physical resistance by the victim means she consented to sex, and a child under the age of 13 years is not capable of consenting to penetrative sexual acts. In Fiji, sentencing tariffs for rape of a child has been widened from 11 to 20 years imprisonment, and for rape of an adult woman, the tariff is from 7 to 15 years imprisonment. Life imprisonment has been imposed where the two rape victims suffered significant psychological harm in a truly horrific case of campaign of rape of his daughters by a biological father. While reforms have been made, there still exist systematic barriers for women and children to access formal justice. We all know that a formal courtroom atmosphere can be daunting for ordinary people, and more so for the vulnerable victims of sexual violence. A number of special measures are now available under the Criminal Procedure Act Fiji for vulnerable complainants and witnesses to ensure they are able to give their best evidence. Some of these measures are evidence of the victim is received in closed court or through a video link from a separate room, use of partition or screen to shield off the victim from the plain view of the accused, use of female interpreters when the victim opts to give evidence in vernacular, presence of a support person for the victim when she is giving evidence in closed court. Support person is usually a person who is not a witness in the case, but had some contact with the victim as a counselor and had built some rapport with the victim. Name suppression for the victim in order to protect her identity. The Fijian courts have also adopted through the Bench Book on Children comprehensive guidelines on how to ensure children are able to give their best evidence and to ensure a fair trial for both the accused and the child complainant. In addition to the use of special measures for vulnerable witnesses, the following additional measures are being used by the courts to receive the evidence of a child complainant. 1, dispensing with wigs and robes. 2, modification of the courtroom layout to make the child witness at ease. 3, rapport building with the child witness by the trial judge before the evidence is received. Use of regular breaks during the recording of the evidence of the child witness. Use of body maps, drawings, and other testimonial aids by the child witness. Controlling improper examination and cross-examination of a child witness. And this last measure is very important. In the case of Narayan and State, the High Court of Fiji emphasized that the practice of having a child witness repeat in cross-examination the account given in examination in chief to try to elicit inconsistencies is unfair to the witness and has little or no effect on credibility. The High Court took a similar view in State against Raj, which is my case, by restricting the defense lawyer from conducting unduly lengthy cross-examination of a child complainant by asking questions on peripheral matters based on the witness's police statement and confusing the child. In that case, the court further warned counsel of more stringent special measures if counsel did not change his tactics. Unfortunately, the same safeguard has not been accorded to cross-examination of adult complainants of gender-based sexual violence. Lawyers continue to use rape myths and stereotypes during cross-examination to discredit the rape complainants. Studies have found that defense lawyers drew on a wide range of rape myths to undermine the credibility of the complainant, to blame her for the assault, and to make her appear unworthy of the protection of the law. Many victims feel that they are raped all over again during the trial. A recent study of experience of victims of sexual offences in New South Wales District Court in Australia revealed many sexual offence trials featured practices that lead to traumatic experiences and negative outcomes for the victims, and that the use of rape myths and stereotypes by the defense counsel to cross-examine the complainants in order to discredit them featured in almost 70% of the trials subject of the study. You may have come across the case of a talented English violinist, Frances Andrade, who accused her former music teacher, Michael Brewer, of indecent assault. A few days after giving evidence in the trial, Andrade, the victim, killed herself. 3 days before her death, Andrade wrote to a friend to say that she felt as if she had been raped all over again when the defendant's barrister, who happened to be a woman, attempted to undermine her testimony. As soon as she came out of the courtroom, she just burst into tears. She had tried so hard not to do it in front of the jury. She described it as feeling as she had been assaulted all over again. All that she could think was that she was being attacked. She found that extremely hard. Her perpetrator was eventually found guilty of 5 counts of indecent assault. But during her time in the witness box, Onraid was very clear about the effect that the aggressive tone of questioning would have. She said, and I quote, "This is why cases don't come forward," she told the defense lawyer. "I am not in the realms of fantasy, and I really understand why so many cases have not come to court." These were her words before her death. Many victims of sexual and gender-based violence share the same traumatic experience of the judicial process as Onraid. Too often, they feel they are treated as an afterthought, or that the system made their already horrific experience worse. They describe the experience of having their evidence torn apart by hostile questioning distressing. Gender inequalities are among the most all-pervasive, though deceptive, subtle forms of inequality. A survey conducted by the Fiji women's rights movement in 2016 found that 2 in 3 victims of gender-based violence face difficulties in going to the police or court, either because the police told them to resolve the issue within the family or village, or that the police did not take them seriously, or that they did not know about the court process or where to go, or that they faced fear of stigma or physical attack. Women and children don't report crime or are not willing to give evidence in court because of fear of further victimization by the very legal system designed to protect them. They fear not being believed if they report or complain of sexual and gender-based crimes. Despite many countries adopting the principle of equality before the law in their constitutions, gender norms, rape myths, and stereotypes seep into the legal system unnoticed and unchallenged. This means that women and men experience the same laws and legal systems differently. However, the state has positive obligations to protect women from any form of violence by adopting special measures that are effective and accord them protection. Fiji and many of her neighbors are party to the Convention on the Elimination of All Forms of Discrimination Against Women, which calls upon state parties to eliminate all forms of gender-based crimes and requires states to act with due diligence to prevent violations of rights committed by private persons or to investigate and punish such acts of violence. The CEDAW committee has also expanded upon the duties of the state in relation to violence against women in General Recommendation 19, which recommends that, and conclude my presentation with the 2 important recommendations. State parties should take appropriate and effective measures to overcome all forms of gender-based violence, whether by public or private act. And secondly, state parties should ensure that laws against family violence and abuse, rape, sexual assault, and other gender-based violence give adequate protection to all women and respect their integrity and dignity. Thank you.
Thank you very much, Justice Goundar, for your very insightful, remarkable views on the presentation you just presented. And it makes us even more grateful for that we're on the right track of some of the work that we're doing on our model provision to incorporate special measures for vulnerable witnesses. We do have some questions for you from the floor. I would like to read them out to you if you would like to take them, and perhaps some other members will also be asking questions to you. The first one is, what else needs to be done to complete the paradigm shift in judicial attitudes?
I think to begin with, and which we have already started, is training for judicial officers. And gender-based crimes and how to manage victims of gender-based crimes, they form a very important part of our work as judicial officers. If you look at our statistics, almost every second trial that is run in the High Court, which is the main trial court in Fiji, is a sexual offense trial. And since it forms a large part of our work, right, I think training is very important. We have already started to have internal training on these issues, how judges should be dealing with sexual offenses and how they should be dealing with the victims, the complainants and witnesses of sexual offenses and gender-based crimes, and have that empathy and able to apply the practices, the rules and laws that afford them protection in the cases. So that is a starting point, but that is one aspect of it, isn't it? The trial, the conduct of the judge. The other aspect, I think the area that I'm more concerned about is the conduct of lawyers. And they do have a duty to also afford protection to the victims of sexual and gender-based crimes. At the moment, we have identified a problem. It's just not a problem just in one country. It's in developed. It's a problem in an advanced jurisdiction like Australia. The study that I have referred to in my paper on the trials of sexual offences in New South Wales District Court is the most recent one. It's a 2023 study, and it has been done by two academics, Professor Quilter from Wollongong University and another professor from New South Wales University. And they have looked at transcripts of about 70 to 100 trials. And what they have identified a real issue, a real concern, that although that there have been so many improvements done in this area, we have brought all these special measures and order protection, but still somehow rape myths and stereotypes still are part of the process. And it's done to discredit the victims of sexual offenses. So ultimately, we have to start looking at, of course, training for defense lawyers as well, which I think is happening in Fiji. But we may have to also look at code of conduct. Maybe we have to, for lawyers, when they cross-examine victims of gender-based crime, whether this should form part of these should form part of code of professional conduct for lawyers as well. But something that you might have to start thinking about, start working on it. So it's not just that's a simple solution. It has to be a combined effort of all the stakeholders that are involved in the criminal justice system.
Thank you very much, Justice Goundar. Will you be able to share some of your paper, please, that you've just presented?
Yes, I can send it to my secretary in Fiji, Una. I think someone has been in contact with Unese, and she can forward it to the secretary of PILON. And then I'm happy that my paper is in, yeah. I'm happy to share my paper, yeah.
Thank you very much. Does anyone on the floor like to provide a comment? While we have Justice Goundar with us at the moment.
Okay, thank you very much, Society Alpha Justice Goundar. Thank you very much for your presentation today. It's been wonderful listening to your perspective. I just want to take the opportunity to ask the judiciary's perspective on the no-drop policy. We just had a brief discussion on this side about it. What is the judiciary's expectation of, say, the prosecutor in particular? Well, because of the no-drop policy, a case is still brought to court, but the prosecutor themselves is not confident of evidence being sufficient to prove beyond a reasonable doubt.
I'm sorry, I didn't hear your question.
Sorry, can you hear me?
Yeah, I could not clearly hear your question. I can hear you now.
Okay, I'll try again. So we were just having a discussion on this side about the no-drop policy.
Yes.
We have the situation where the policy is applied strictly by the police.
Yes.
But it's not as, well, from the prosecution's perspective, there's a discretion as to whether a case should still be pursued or not, regardless of the victim wanting to withdraw. What I'm asking is, from the bench or the judiciary's perspective, what is your expectation of a prosecutor who brings a case regardless because of the no-drop policy, but as prosecutor is not confident that the evidence is sufficient to move beyond a reasonable doubt?
Yeah. All right. My understanding of how the DPP has been operating on no-drop policy is that, of course, they have to abide by their own manual. They will only bring prosecution if there is a reasonable prospect of securing a conviction, and if they find out that through witness conferencing before the trial, that the complainant, for some reason, is reluctant to give evidence or maintain hostile, what they have done is, rather than putting the witness on the stand and commencing the trial resulting in an acquittal in no case to answer stage, and then you can't bring the prosecution again, they nully prosecute the case. And as you know, that in Fiji, unless they are acting in bad faith, we don't question the discretion of the DPP to drop the case. And there have been cases where they have nullied the case, and but later on, after counseling, after making the inquiries and all those things, investigation, they have brought the case back, and they have conducted some very successful prosecution of cases where victim had been reluctant in the first instance, but later changed the mind with counseling and support and secured conviction. So that's how it works in Fiji. We don't question, as the courts don't question why a case is not prosecuted and not prosecuted. That's entirely, we leave it to the DPP's office to make the decision, especially in the High Court. But I think there are DPP's officers from Fiji present. They might be able to give a much clearer answer as to what they do in the office before they take up the matter to court. Yeah.
Thank you very much, Justice. That's helpful.
Thank you, Attorney General Oxanpo. Are there any other further questions? Judge Goundar and Sandy Drew, welcome and thank you very much for your thoughtful and thought-provoking presentation.
And he's a former colleague of DPP's office.
Judge Goundar, I think your first comment on the training aspect of judges rings through various facets of our work, not only in sexual gender-based violence cases,
but corruption space and in other areas. I think the traditional approach to prosecution, where prosecutors get trained in isolation of the investigators, in isolation of the judges, is long gone. We can't work in isolation of each other. So while we have trainings that are geared for prosecutors, for support officers, victim liaison officers, it's time to have judges come to the table. And your comments in relation to how cases are to be prosecuted and that expectation that defense counsels need to be a lot more, to show more empathy, to be more gentle, calls to questions whether a code of conduct needs to be adopted in this area of our work, which rings true right through the Pacific. Because it's so different from a fraud case, for money laundering. We're talking about people's families, our very own, something closer to home. And so your comment, I pray, when it's being recorded and it's being shared, is shared across the Pacific. So thank you very much for that.
Thank you, Ms. Chu.
On the second question in relation to the no-drop policy, as you rightly mentioned, in jurisdictions such as Nauru, Fiji, and in most Solomon Islands, Vanuatu, the courts will never question the filing of the Nadi prosecution. That's venturing into a space that's constitutionally protected, and I don't think courts would go into that. Something that would arise from it is the problem we'll face with our police, because police have a no-drop policy to investigation, and they get very frustrated when the DPP's office responds by saying there's insufficient evidence. And that's something that we face in our rule. So a guideline, so to speak, to make both stakeholders understand their roles might be a way forward in relation to it. But at least at the end of the day, we think about the victim's background, the victim's sanity through this whole process. And empathy must always be given towards the victim. And we really don't want to face a case like you mentioned, which I'm quite familiar with, where the victim killed herself. So thank you, sir, for your presentation.
Bye-bye.
Thank you very much, DPP Nauru, for your very insightful comments. Are there any other questions? I just have one question, Justice Daniel Goundar. Would you be available to be a speaker in our other workshops that we can come to and ask you if you could provide some guidance in?
Daniel, they want you to come back to other presentations.
Yes, at the moment, well, I'm importing a very important function. I'm a full-time house husband. I think it's very important I do that because it helps me understand and appreciate what my partner has been doing for me the last few years when she sacrificed her teaching career and to look after me and my children. It was her decision, but now that it's my turn to, and I appreciate that the sacrifices women make when they decide to keep the family together, So my wife is a full-time teacher here, and but I have to look after the children, look after the house. But I'm free during the day. As I say, I'm happy to assist in whatever area you want. I can assist in. I'm happy to do that. You have my contact now. And if you can send your inquiries and email to me, I'll see in whatever area I can assist, for my area, assistance to you. Yeah.
Thank you very much, and May you have a lovely day and thank you again.
Sure. Bye-bye.